I'd like to introduce our next panel of international justice. As members of the Armenian diaspora, we all read and followed the horrors of the 2020 war. And as diasporans, I know we all felt some form of anger, guilt, or helplessness during that time, as well as in the aftermath. What can we do to get justice? And what can we do to get the world to recognize the injustices perpetrated against our people? Representatives for Armenia at the International Court of Justice, the principal judicial organ of the United Nations, have been taking on that monumental task head on. The case of the Republic of Armenia versus Azerbaijan was brought before the ICJ in October of 2021. Members of the legal team called upon the tribunal to protect and preserve Armenia's rights and the rights of Armenians from further harm, citing the urgency of international intervention for the sake of Armenia's security. We are thrilled to have 3 of the 23 members of the exceptional legal team who represented the Republic of Armenia here with us today. Dr. Yerishe Giragosyan, Levon Gevorgyan, and Karnik Kerkonyan. Thank you. They will be introduced momentarily and in more detail by our distinguished moderator, Garo Ghazarian. These renowned legal minds will not only unveil the intricacies of the 2021 legal cases against Azerbaijan, but also discuss the current legal proceedings initiated by the Republic of Armenia against Azerbaijan at not only the ICJ, but as well as the European Court of Human Rights. Our moderator, Garo Ghazarian, is a native of Beirut and a Los Angeles-based criminal defense attorney, specializing in complex white-collar federal cases, homicides, and serious felony offenses. He serves as the City of Glendale's Civil Service Commissioner. He is the former Dean of the People's College of Law and a law professor who has lectured extensively at the FBI Academy, Sheriff and Police Academies, and at universities in the US, Armenia, and Artsakh. Mr. Ghazarian has served as a board member of many Armenian organizations, including the Armenian Bar Association, the Armenian Center for National and International Justice, and the Armenian Genocide Centennial Committee, who organized the 166,000-strong Los Angeles March for Justice in 2015. In 2017, he and his late father filed claims against Turkey in U.S. District Court for civil rights violations, obtaining a default judgment against Turkey. And together with his colleague, Karnik Kerkonyan, here on the panel today, he hosts Frontlines, a globally recognized talk show on Armenian matters. Over the years, Mr. Ghazarian has appeared on numerous media outlets, including CNN, Fox, and Al Jazeera English TV. He currently serves as the chief advisor to the Tatoyan Foundation, Center for Law and Justice. Ladies and gentlemen, please help me welcoming Garo Ghazarian.
Ladies and gentlemen, good afternoon. I would be remiss if I did not begin by expressing my deepest gratitude for the lengthy and unrelentless efforts of the Armenian National Committee of America Western Region. I'd like you to please join me in giving a round of applause. Many years ago, I coined a phrase. I'd like to take credit for that phrase, but the phrase represents what this organization has done, is doing, and I know will continue to do. Sword and shield. I've heard that phrase since, utilized by others in describing this organization, and it should be often and often. You see, those who think that the ANCA Western Region is engaged only in shielding us from harm, they are mistaken. Because it is only by exercising its effective advocacy, the sword that it uses, the power of the tongue and the word, that they are able to shield us. And each and every one of you here today, I am grateful to each and every one of you for being here, for supporting the efforts of the ANCA Western Region, and I hope to see you again tomorrow and in the days ahead as the ANCA Western Region continues in the spirit that our esteemed Honorable Minister of Foreign Affairs of the Republic of Artsakh alluded to during his keynote address at the luncheon. Every single act by each of us is consequential to our homeland. Every single act by each of us is consequential to our homeland. Each of our actions and reactions either weaken or strengthen our nation. Our homeland's independence of May 28, 1918 is a vivid reflection of that concept. Our homeland's independence of September 21, 1991 is yet another example of that vivid concept. And today, tomorrow, and every day thereafter, we ought to remind ourselves that every action and every reaction is consequential in either weakening or strengthening our nation. We will hear this afternoon from three gentlemen, three scholars who adhere to these principles, and by all accounts, I can attest to, they act accordingly. I have the distinct honor and privilege to introduce them to you as the moderator without the doctorate degree, because each of them have doctorate degrees. To my left, to my immediate left, is Dr. Yerishe Giragosyan, a native of Yerevan. Dr. Giragosyan is the representative of Armenia on international legal matters, including ICJ and ECHR, that's the International Court of Justice and European Court of Human Rights. He has an extensive experience of working with the Armenian government since 2008, that's some 14 years ago, in the capacity of an assistant to the Prime Minister and later as Deputy Minister of Justice. Dr. Giragosyan has been a lecturer since 2006, teaching law at the Yerevan State University and the American University of Armenia. His research and academic focus include international courts and arbitration, responsibility in international law, countermeasure and enforcement of international law. Dr. Giragosyan is the author of numerous publications, as well as the founding editor-in-chief of Armenian Yearbook of International and Comparative Law, published since 2013, which in addition, by the way, before I forget, in addition, Dr. Giragosyan, to being the representative of Republic of Armenia before the ICJ, that emergency order, which we will discuss shortly, continues to be deliberated, the emergency order that was secured, it continues to be deliberated in the matter of Republic of Armenia versus Azerbaijan case, which is, by the way, the first such case ever brought by Armenia before the World Court. Immediately to Dr. Giragosyan's left is Dr. Levon Gevorkyan. He too is a native of Yerevan and an expert in international law and a candidate in juridical sciences. He is Digitain Armenia's chief legal officer, heads Genesis Armenia's legal division, and was the senior manager of Ernst & Young, CJSC, and head of legal practice in Armenia. Previously, he worked at Public International Law and Policy Group law firm in Washington, the UN Legal Affairs Office's Codification Department in New York City, and the Department of Relations with the European Court of Human Rights at Armenia's Ministry of Justice. And yes, he is my friend. You are my friend. Dr. Gevorkian has been lecturing on international humanitarian law at the Yerevan State University and the American University of Armenia. He was a member of the team of lawyers, along with Dr. Giragosyan, representing the relatives of Gurgen Margarian against Hungary and Azerbaijan, as well as of the working team that prepared an amicus curiae presented to the European Court of Human Rights in the Perinchek versus Switzerland Armenian genocide denial case. And lastly, Dr. Gevorkian advises on the Republic of Armenia's case against Azerbaijan at the ICJ. Immediately to Dr. Gevorkian's left is my dear friend and longtime colleague, now Dr. Karnik Kerkonian, who I'm very proud of, Karnik. Karnik Kerkonian holds an AB, magna cum laude, from Harvard University in Government and Legal Philosophy. He also holds 2 law degrees, a JD from the University of Chicago, where he served on the Law Review, as well as a postdoctoral diploma in international law from Cambridge University, England, where he studied under James R. Crawford, former judge on the International Court of Justice. And most importantly to me, and I believe to Karnik as well, he holds an honorary doctorate from Artsakh State University in Stepanakert. Karnik is a seasoned international lawyer and an experienced litigator, a founding partner of Kerkonian Dajani LLP. He currently leads the Evanston-based Law Firms International and Federal Practice Groups, focusing on complex litigation matters, Foreign Sovereign Immunities Act litigation, the Alien Torts Claims Act, and commercial sanctions regime matters. He also serves on the team representing the Republic of Armenia at the International Court of Justice with his fellow panelists in the pending matter Armenia versus Azerbaijan and Azerbaijan versus Armenia. Dr. Kerkonian has litigated several high-profile Armenian rights cases in U.S. courts, including serving as pro bono counsel for my late father and I in the matter of Gazarians versus Republic of Turkey and Republic of Artsakh versus L3 Harris Technologies, also pro bono. And he has represented the National Museum of Armenia, also pro bono, in the identification of the Armenian origins of museum artifacts, including the bejeweled gun of Sultan Mahmud, housed at the Walters Museum in Baltimore. Together with me, or rather I with him, because it was his brainchild, we are the co-host of Front Lines, some say a globally recognized talk show, according to the notes I was given, on Armenian matters. I don't know about that, but thank you for the author. And I know that when midnight hits in Chicago, Karnik lectures public international law at Artsakh State University via Zoom and has been doing so for quite some time now. And I began and I will conclude, most importantly to me, he is a senior advisor of the newly founded Tatoyan Foundation, our dear Arman Tatoyan, the Center for Law and Justice, where Karnik is the main advisor on international law, and wish us luck and join us as we go forward with our endeavors. So now you have heard these 3 distinguished panelists' biographies. I would like to invite Dr. Giragosyan, followed by Dr. Gevorkian, followed by Dr. Kerkonian, to make brief remarks, not too much longer than mine, and then we will go into question and answers. Thank you. Dr. Kiragosa?
Thank you. Thank you, Gar, for introduction, and thank you for organizing this event and inviting. It's an honor. It's an honor to be here and to present during the Grassroots Conference. And I will be describing the main legal proceedings that Armenia has initiated in different international courts. And I think that will be and if you'll have any questions relating to those proceedings, I'll be happy to answer. Before starting that, describing the substance of the steps undertaken by the Republic of Armenia in that regard, just wanted to emphasize the importance of the international law and international legal proceedings for foreign policy in general. And I think that as a country, as a nation, that when we are let's say, complaining about the problems that we're facing today or the problems that we have now, we have to be mindful of our own shortcomings, what we haven't done enough, or what we have omitted, what we have done wrong. I think one of the avenues that we should have, I think, as an independent and sovereign country from the very first day of the independence pursued is the triggering of international legal tools and using international law. We failed doing that. I think we failed doing that with regard to Artsakh conflict too, properly. And I think that's why we are seeing the results that we see today. We are late now, I know, but I think it's never late than never. We should continue pursuing that, and I think the international law, although many people, statesmen in Armenia, also a lot of people in Armenia, a lot of people outside Armenia, can be highly skeptical towards international legal tools, and I'm sure that among you, many people are skeptical and will be skeptical, and I think I will be receiving a lot of skeptical questions now. I'm ready. But nevertheless, we have to be patient. That's important. We have to be really thorough in understanding what that means. It's not on the surface. You have to look it deeper. And international law is crucial for countries like Armenia. It is crucial, it is vital. And it's not for great powers, it's not for big states, because great powers and great geopolitical actors can solve their issues by many other means that they have at their disposal. Small countries like Armenia, small states like Armenia should be very actively been engaging with those tools, because that's also helping to re-emphasize the sovereignty, to strengthen the sovereignty, to amplify the voice of the country on the international arena, and also make the voice more founded, justified, and heard, and understood. That's very important. So just this is a remark, a general introductory remark, which I think it is the starting point, it is the underpinning of the philosophy, underpinning philosophy of this whole actions that have been initiated by the Republic of Armenia. The occasion of, or the trigger event that pushed Armenia also to start many legal proceedings was not that, it was the negative trigger, but it was a trigger. Because of the 44-day war, as a result of the 44-day war of the 2020, we were witnessing many human rights abuses and violations happening throughout the conflict and in the aftermath of the conflict. And of course, those human rights violations, abuses, and crimes have been documented well. And the first case that Armenia brought before international courts was the case brought against Azerbaijan at the European Court of Human Rights. That was done right after the end of the hostilities in the beginning of 2021. And after that, Armenia has brought several other proceedings to the European Court of Human Rights against Azerbaijan because, unfortunately, after the end of hostilities in the course of 2021, 2022, we continued seeing other instances and incidents of abuses and attacks and aggression continued against Armenia, against Artsakh. And at this point, we have at least 3 interstate proceedings at the European Court of Human Rights only against Azerbaijan, 1 interstate proceeding against Turkey, again at the European Court of Human Rights, which relates to the same fact pattern as the first application submitted by Armenia against Azerbaijan in 2021 February, claiming that Turkey's involvement in a conflict and Turkey's culpability for the violations committed during the conflict and in the aftermath of the conflict. And those cases are pending at this point, the European Court of Human Rights. The first application is pending before the Grand Chamber of the Court. Now we are close to completing the written proceedings with regard to that application, which means that the next iteration, the next stage of the procedure will take us to oral hearings next year, and most probably next year in Strasbourg. And of course, we have also the recent escalation, the recent aggression against sovereign and undisputed territory of Armenia, which has been already documented and is submitted to the court already, and of course will be submitted to the court as a separate application in due course. That is being conducted as we speak, because we have submitted numerous requests to apply interim urgent measures with regard to Azerbaijan, because unfortunately we have been receiving numerous evidentiary materials circulating in social media by Azerbaijan of abuses of Armenian POWs, and also abuses and mistreatment of POWs. Not only that, but also mutilation of dead bodies of soldiers, and many other very heinous war crimes and aggression. And that's very those which are the result and direct result of the other problem, deep-rooted, which I'll be speaking in a moment, the hatred and the animosity towards ethnic Armenians. Apart from the European Court of Human Rights, I think there is the other important proceedings which Armenia has brought at another international court, which is the main judicial body of the United Nations, the International Court of Justice. The case concerning the interpretation and application of the Convention on Elimination of All Forms of Racial Discrimination. This is a very important convention that I think I want to emphasize the importance of this convention. We have been, I think, thinking about this applicability about the convention for quite a long time, and I think it is quite more than evident what's happening inside Azerbaijan from the past decades. It is what exactly is prohibited by this convention. The meaning and the purpose and the object of this very convention is exactly what Azerbaijan is diminishing every day and has been diminishing for the past decades. And they're and the problem with that, of course, is a bit different. I think that why it is happening, it's another different question, because the convention that we're speaking of is not some unnoticeable human rights instrument. I think the Convention on Elimination of All Forms of Racial Discrimination is a fundamental treaty of human rights, which was adopted very soon after the end of the Second World War, and even before the two very major human rights instruments, 1966 Covenants of Human Rights, were adopted. It is, I think, highly fundamental and crucial document, I think, on equal footing with the Genocide Convention. Why? I think because the actual prevention of genocide should happen and will happen only if the provisions of this convention are respected. If they are not respected, if the Convention on the Elimination of All Forms of Racial Discrimination is not respected, it is violated and breached, that will lead to many genocidal acts. That's how genocides happen. They don't happen overnight or over a day or over a month. It accumulates, the hatred accumulates, and the policies of racial hatred and animosity, they are being built up as they have been built up already. They continue being built up today inside Azerbaijani society. And Armenia has brought this case exactly more or less a year ago. We submitted the application on instituting proceedings to the court on 16th of September 2021, and we submitted also not only application, but we also submitted requests on indication of provisional measures with respect to the preservation of interests under the convention. And we famously, I'm sure that most of you know, the ICJ, the International Court of Justice, held hearings in The Hague based on Armenia's request to indicate provisional measures, where Armenia's legal team and colleagues present here at the table, and also many other colleagues and lawyers and highly qualified lawyers who are also on Armenia's counsel team, presented Armenia's argumentation before the court. And the requests, the application, of course, as I said, is relating to the decades-long Armenophobic policies, which includes many aspects. The aspects are including the hateful rhetoric by the political leadership of Azerbaijan, all levels, starting from the highest level, ending to the lowest level. The purported and very meticulously structured hatred policies through educational materials, which is down on every level of the education, starting from preschool, going to school education, and then university education in the textbooks. And the hatred towards ethnic Armenians is implanted, is seeded like there. And the generations with that hatred are being brought up, and that's the problem with that. And it is the cynicism is so high that the leadership of Azerbaijan, Ilham Aliyev himself is admitting after the end of the hostilities that their so-called victory is due to generation brought up in the spirit of hatred towards enemy. And they are proud of that. That's the very sad part, because I think here we have, and we can discuss on that, we can elaborate on that. I think we do have a crisis of values today in the international community. It is not only, I think it is exactly why such countries exist. It is not normal to have a country to propagate hate and go that far from the proclaimed values of humanity after the Second World War. You have documented values, but there are countries which are really going further away, like they're going very far. The gap is really high. It's not just minor violations, it's complete disregard of the fundamental principles of international and also that convention. In Armenia, not only that, but also that the hatred and animosity and racism is, as today in the morning it was presented, it is evidenced in many forms, including also by the attempts and very concerted attempts to erase anything Armenian that is under Azerbaijani control. And that includes the cultural monuments, that includes the historic monuments, churches, cathedrals, anything Armenian that is Armenian, or crossstones, cemeteries, and anything that connects Armenian to that land should be erased or altered or presented or falsified something else. That's another form of the that this hatred is being presented, or it presents itself. And it also starts, these attempts are also leading up to the attempt of falsifying history, which is a phenomenon also very much known to us from the early days of Soviet Union, like starting from at least 30s of the 20th century, when the Soviet Azerbaijan started also to prepare for that generation of scientists, in quotation marks, to conduct this build-up of a narrative for their nation, and also which included also falsifying the history, which included also for building up a history on the expense of the Armenian history. That's the other way that is being revealed, which is a step to conduct to justify also their existence. All these and many other evidentiary materials and other incidents have been documented and are being documented, and we have presented in the application already a number of evidentiary materials confirming all of the mentioned above, but we are now currently working on the main submission in the case, which is the memorial, which will be encompassing all of the legal arguments presented by Armenia, accompanied by evidentiary measures and materials, which will be submitted to the court in January 2023. And of course, you remember about I'll speak 2 words about the provisional measures, and then I'll conclude. You remember the provisional measures request which Armenia presented to the court. They included several requests that Armenia asked the court. Armenia asked the court to, first of all, to order Azerbaijan to terminate all hateful rhetoric by including public officials, and high-ranking public officials especially. Armenia then requested the court to ensure the rights of the persons of Armenian ethnic origin that are under the control of Azerbaijani agents. And also we asked also to order repatriation, although we knew the risks of that request. And we also requested the court to order Azerbaijan to oblige Azerbaijan to preserve Armenian culture, monuments, and heritage under the control of Azerbaijani forces. And there was also a request relating to the so-called Military Trophies Park. I'm sure that all of you know about Military Trophies Park, which included also exhibit of mannequins of Armenian soldiers in a very highly pervasive, very racist manner, and also the helmets of the fallen Armenian soldiers created in that park, and which goes against the spirit and the object and purpose of that convention. We were asking the court to order shutting down the park and either suspending the activities of the park until the end of the proceedings. The court ordered, of course, most of the requests that we put there. The court ordered the suspension and termination of the all Armenophobic statements and policy statements by the political leadership, including the high-ranking officials. The court also mentioned the danger that the statements, the Armenophobic and hateful statements by high-ranking public officials have with regard to the physical and psychological integrity of people of Armenian origin under the authority and control of Azerbaijani agents, because the idea of this impunity that has been created through that statement, and also it's not only the impunity, but also I think we had a mention about Safarov's case today in the morning. That's one of the heinous examples of this impunity, when Ramil Safarov was not only released as soon as he arrived in Baku from Budapest, but also he received the salaries of the years absent. He was glorified as a hero and as an example for the generations. That's the problem. It's not only that there is impunity, no one is being held accountable. No, it's just on the contrary. People are being praised for just killing Armenians peacefully in their sleep, and or cutting heads during a conflict of civilians or elderly. They are being awarded. And all those are, this is very intertwined, and the essence of the case is very rich now. And the evidentiary materials presented to the court are really very powerful, what I think. And the court ordered, of course, based on the evidentiary materials that presented that Azerbaijan should take necessary steps to terminate all the hateful rhetoric and racist statements. And also we had a measure applied by the court relating to the preservation of the cultural monuments, the holding accountable of those who are vandalizing the cultural monuments and Armenian cultural monuments under the authority of Azerbaijan. But also we had the measure with regard to ethnic Armenian captives, to Azerbaijan, obliging Azerbaijan to respect their rights guaranteed under the CERD, the convention. And there is also the general measure applied by the court relating to the non-aggravation of the dispute in the future, which is a very ordinary measure applied by the court in such circumstances. Unfortunately, we have not received we have been following up, of course, afterwards when the order came out back in December 7, 2021. We were looking very closely the behavior of Azerbaijan, whether it changed or not, because that's also another step in enforcement of international law. It's not only that we apply to the court, we trigger the mechanism, but also the next stage, the next iteration is to see how the order is impacting the actual behavior of a country, in this case, Azerbaijan. Of course, we don't have that much, we're not that naive. We understand that the society, the dictatorship or the autocracy, whatever regime it is, created based on the philosophy of hate. It cannot change in one day. It's not feasible, it's not possible, because generations have been brought up on that spirit, and you cannot erase that generations. They think in that manner. And of course that will take time, but still it's important. And of course, we have noticed some minor incidents of change in the behavior of the country, but those are not, of course, satisfactory. One of the examples that we noticed was the quick reaction of Azerbaijani authorities even before the order came out, during the hearings in The Hague, during the proceedings, when Armenia requested the closure of the Armenophobic military trophies park. We received among other things, also because of the mannequins or because of the helmets being exhibited in that park, we received a quick reaction from the Azerbaijani government, a letter to the court, and also announcement made by their agent during the hearings that those mannequins and helmets have been removed from the park. And the commitment that the agents undertook during the hearings that those will not be re-exhibited again. Although this is really a very tiny and minor step, I understand, but still this is something that indicates that I think one of the reasons that this happened, why it happened, I think there is a question why this happens, because they shouldn't care that much about international law, right? But I think one of the reasons that this happens was because we had public hearings in The Hague at the International Court of Justice. We didn't see such reactions or such behavioral changes when we were having the written proceedings at the Strasbourg Court and European Court of Human Rights, which is more or less low profile because of not being public hearing. And the public hearings are making also these evidentiary materials to be seen to the world. And that's also having an impact related in a way that is also harming the reputation of the country that they are trying to build, because they, although they are, that's not the fond of international law, but still they want to be seen as very nice, very pluralistic country, very country that abides by international law, which is cynical, of course, but that's true. And they are, that's very nature that they want to, and they are acting in that manner, even in relation to Armenia in the international legal proceedings too, by the way. This is the overall, the structure, what has been done so far. And of course, in the framework of these proceedings that we have at the courts, I mean the International Court of Justice, we continue to feed the court with new evidentiary materials that come out, and we continue to submit new requests to the court in the line that, in the meaning that we need to observe the implementation of that order. We want to always notify the court and draw the court's attention to the facts on the ground. We have done it after the recent attacks on Armenian sovereign territory. We have done it in August. We have done it back in March when there was an escalation in Artsakh around Paruch, Karagluch, and the gas supply suspensions that were happening. And we have done it when the working group was created in Azerbaijan with regard to the Armenian cultural heritage monuments aimed at falsifying further and altering the true nature of Armenian cultural heritage. And the ask that we have for the court in those requests, starting from back March, ending with the most recent submissions that were made to the court. The first one were relating to the creation of so-called 3 judges panel, which is a mechanism under the rules of the court to monitor the implementation of the order. We have been insisting on that request over and over in the past more than half a year. And on top of that, because of the recent attacks on Armenia, we also asked the court to, because of new captives that we have, new POWs, and because of the treatment issues, we asked the court also to modify the court's order, to extend the application of that order to the new captives too. And we are waiting for the new developments soon. We hope that the court will be swift enough to address our requests. This is all in regard to the substance of what I wanted to convey to this distinguished audience. I think this may trigger some questions that you will have. I will be happy to answer to any of those. And this just a quick summary of what has been done, because there are many other processes that are ongoing at this point, which I cannot reveal, and I should not reveal at this point. I think you'll learn it in due course. And I just want at the end to re-emphasize the importance of this international legal proceedings. I know that we want an immediate result, we want a quick result, but this is not the case for the international legal proceedings, because international legal proceedings do not have that tendency of creating a quick and immediate impact. They may, we hope so, but mostly the strategy of behind this legal proceedings a bit more far-reaching. And I think those are, we have to build up on this as a sovereign state. That makes the country stronger. And also it is an important tool, and it is creating an important atmosphere for the diplomats to work. And it is also creating a lot of I think it is very helpful for diplomats too, and for the Armenian foreign policy, because that's adding up another layer of argumentation, another layer of more persuasive and justified arguments that diplomats and foreign policy makers and decision makers can use to advance national interests of Armenia. I think this is all. I'll conclude here, and then I'll look forward to your questions. Thank you for your attention.
So thank you so much, Garo, for the introduction, and thanks, everyone. I cannot stress enough what an honor it is to appear here today. Mr. Kyriakosyan made a short introduction about the importance of the international proceedings. I'll try to elaborate on the importance of those cases a little more, and I'll also try to talk about what ultimate goal can be sought by Armenia and Armenians in general through these proceedings. So, starting from the beginning, unfortunately, we have to admit that for decades, Azerbaijan has been using legal diplomacy and incorporating legal diplomacy into its foreign policy, and using it as a narrative-building instrument. What Azerbaijan was basically doing, it was flooding international organizations with various memoranda making speeches, making presentations about its own understanding of the Nagorno-Karabakh conflict, and basically building the pro-Azerbaijani narrative, which, if we sum up, pretty much could be defined in the form of various main talking points. So talking point number 1, Nagorno-Karabakh is a puppet state. Talking point 2, it's a de facto organ of the Republic of Armenia. 3, Republic of Armenia is an aggressor state that has invaded part of Azerbaijan. 4, Armenia is a continuous aggressor through its occupation. And finally, because Armenia is in continuous state of aggression or occupation, Azerbaijan has the right to self-defense. Well, and let's be fairly honest here, at the moment when the 44-day war began, Azerbaijan has pretty much won the war of narratives. Because the moment that the war began, the narrative that the Azerbaijani side has the right to self-defense against the Republic of Armenia, allegedly, was pretty much a talking point that was acceptable by the majority of the international community. That's why the criticism that Armenia would naturally expect that the international community would show towards this act of aggression by Azerbaijan was not there. And at the end of the day, probably we're the first ones to blame, because when for decades Azerbaijan was committing and investing into this narrative building, Armenia was pretty much always acting in not a proactive manner, but in a reactive manner. So usually we were the ones to react to whatever Azerbaijan would do, instead of on our own creating our own narratives, or I would rather say not creating our narratives, but supporting the actual narrative that is objectively true and represents the realities on the ground. The moment that the first case was filed by the Republic of Armenia, or rather the moment that Armenia notified Azerbaijan about its intention to start negotiations pertaining to violations of the Convention on the Elimination of All Forms of Racial Discrimination, I believe that moment was the moment when there was a drastic shift in the narrative building. Because at that moment, Republic of Armenia, at least on the international legal level, pretty much took the situation into its own hands rather than being reliant on various international players. Now, from that perspective, the filing of the case is, of course, is an act of drastic importance, an act of sovereignty, and an act which, in a long term, can significantly contribute to the Armenian cause in general. Now, let's talk about what Armenia and Armenians in general can expect out of these cases before the European Court of Human Rights, before the International Court of Justice. There are other potential cases that can be filed also, and we probably can talk about those during the Q&A session. But again, what is the ultimate goal? Well, first of all, of course, one of the central goals is that these cases act as a tool of deterrence. Of course, a reasonable question can be, is it really acting as an efficient tool of deterrence if we're still having acts of aggression, if there are still people being tortured, if there are still monuments being destroyed and people are being displaced from their homes? Unfortunately, and this is one of the basic misgivings of public international law, is that its efficiency has to be assessed based on the question, what would happen if we wouldn't file those cases, right? So if we try to understand, if we try to analyze the situation from a perspective where, in a theoretical situation where we don't have those cases, we need to come to the conclusion that we'd be in a much, much worse situation than we're right now. But apart from the tool of deterrence, what would the ideal judgment by the International Court of Justice be, at least from the Armenian perspective? Of course, one of the things that Armenia seeks to achieve is a finding that Azerbaijan is a racist regime, right? The mere finding that Azerbaijan on a state level for decades has violated its obligations under the Convention on the Elimination of All Forms of Racial Discrimination is tantamount to saying that we have a state with a racist regime in the 21st century. Whether it's perceivable or not, but that's the actual reality. Second, of course, we can talk about certain amounts of compensation, which is due to all the victims. And finally, there is also the possibility that the court will make a finding on the right of all the displaced persons to return, which in a long-term scenario is going to operate as a major tool for the protection of the Armenian cause, as I said. But having a judgment is one thing. Incorporating the judgment or capitalizing on that judgment is a completely different thing. What the Republic of Armenia has to do, and not only the Republic of Armenia, I believe it's also something that Armenian communities all around the globe can engage in, is that the proceedings have to become as part of the Armenian narrative in general. The proceedings can operate, and again, we need to also always be cognizant about the realities that we're living in right now. So we have only 2.5 years left for the mandate of the peacekeepers. The proceedings are going to last longer than that. Most probably we're going to have 5 or 6 years in the ICJ, maybe a bit shorter in the European Court of Human Rights. But in any case, the final judgments are going to be delivered at the moment when the mandate, the 5-year mandate of the peacekeepers is going to pass. And again, what are Armenia supposed to do? Well, first of all, in my opinion, and we can talk about that also during Q&A, Armenia has to make clear, Armenia has to take a clear stance in its foreign policy positioning, saying that no concessions pertaining to the status of Nagorno-Karabakh can be made while there are proceedings ongoing before the International Court of Justice. Because the mere idea that proceedings at the International Court of Justice may theoretically end up with a finding that Azerbaijan is a racist regime, any kind of concession on the status of Nagorno-Karabakh and of Artsakh is pretty much going to be tantamount to ethnic cleansing, right? And unfortunately, we're not in a position to mend situations retroactively. So, and from that perspective, the Republic of Armenia definitely has to talk to the international community with the very clear claim and argument that there has to be some sort of mandate for the protection of the local communities in Nagorno-Karabakh until the final judgment is being delivered. Then what Armenia can do after the judgment is delivered. Of course, if there is a finding that Azerbaijan is a racist regime, this has to be incorporated into its foreign policy, and there has to be a very clear-cut, clean message to the international community saying that the judgment itself makes any potential settlement where Armenians of Nagorno-Karabakh have to live under the sovereignty of Azerbaijan impossible. It's not only impossible. It's not only is impossible. It's also pretty much contradictory to all the central values and tenets of public international law that we have today, and therefore, again, this has to become one of the major narrative-building narratives that Armenia and Armenians are supposed to spread while developing Armenia's foreign policies. Maybe, and of course this is theoretical, but why not? Maybe a final judgment would also help Armenia in gaining some recognition by the international community of the independent statehood of Nagorno-Karabakh, pretty much in the same format that we had the situation in Kosovo. With the mere difference that in case of Kosovo, the fact that there was a persecution and ethnic persecution of the Albanians of Serbia was pretty much unanimously accepted by the international community, and there was no need to go to international courts and tribunals for proof and for final findings by international courts. Things may not be very fair in comparison, but that's the realities that we're dealing with, and that's what we need to fight for. A final judgment accepting and recognizing the right of the people to return, of course, can operate as a fundamental tool to mend the status quo that we have in place right now, and probably correct the wrongdoings that happened during the war, creating a more viable environment for the Republic of Artsakh existence. But again, we need to, as I said, be realistic and invest intensively into making these narratives as part and parcel of our foreign policy. And this is also something that I believe that communities within the diaspora can do. Not necessarily, as I said, not necessarily in the format of foreign policy of the country, but in the format of lobbying the matter before various capitals, and before various governments across the planet, across the globe, which may help the Armenian cause and eventually also help us rebuild what we lost during the 44-day war. Probably I'll try to be short, and I'll cut it here. The rest of it, we'll go through Q&As. Yeah? Thank you.
Thank you, Garo, for the introduction, and thank you, Levon and Yerishe, for the detailed assessment of the actual proceedings and possible outcomes and value propositions that the proceedings provide. It's a pleasure, of course, to be here with the ANCA Western Region again today, because it demonstrates its undying commitment to a truly sacred mission. This time, in the most precarious and challenging moment of our recent history. I'd like to commend the leadership of Nora Hovsepian. Her devotion remains unrelenting. Cemented. They're cemented in my mind, and they're cemented in your minds. I'm positive of it. The images of an old Armenian man's head sawed off with a dagger on the floor of a shop in Shushi. Armenian captives prodded like animals by Azeri forces while crawling on their hands and knees. A stamp issued by an actual government depicting an exterminator in a hazmat suit cleansing Artsakh of Armenians. A military trophy park showcasing the helmets of fallen Armenian soldiers. Gruesome mannequins of Armenians for children to see and mock and degrade. The president of a state, a century after the genocide, referring to Armenians, to all of us, as dogs. Yerishe mentioned that there's a value gap in the international community. This is not never again. It's not even close. It doesn't stop. Her body mutilated, across her barren chest, words chiseled into her skin. Her fingers chopped and shoved into her mouth. Her eyes gouged from her head. A young Armenian mother, not much older than many of you here. Cemented in our minds forever. Historians will remind us that history is long, and while unforgiving, it has much to teach. So today, while we endure the heinous, the war crimes, the unending struggles of sovereignty and statehood, the challenges of self-determination, the trials of human rights, we must bring ourselves to peer out of the abyss and glean lessons. And in doing so, we will see that those very concepts, the very legal principles that define them, are themselves in a state of monumental flux right now. The scope of war crimes and even genocide has expanded in our lifetimes. For example, to encompass destruction of cultural heritage, as Simon Malakian's brilliant panel addressed. The concept of sovereignty has never been as tantalizing a subject in international law as it is right now, perhaps not since the Treaty of Westphalia. Today, sovereignty underpins the discourse of military confrontation in Europe, the narratives of economic sanctions pitting East against West, the limits of cyber warfare, and it grips Armenia by the jugular, right at the crossroads of the most dramatic chapter in recent Armenian history. How does this case impact the sovereignty of Armenia? Why does it even matter in this time of existential crisis? I hope we're going to have the chance to discuss this today. The principle of self-determination has literally transformed in our lifetimes. It is no longer the simple tool of decolonization. Within the last 2 decades alone, NATO, Russia, Europe, and Africa have all spoken in its name, and at the most consequential times in their recent histories. Self-determination is an expanding legal right at international law, richer today than it has ever been before. And of course, it is one of the essential themes that will define the most uncertain and perilous corner of the Armenian experience today, Artsakh. What have we missed? How have we allowed Artsakh's self-determination to be relegated pariah in a world discourse that has room for the creation of states in Europe, from Africa to Asia? What have we missed? This is not just power politics. There are international law discourses at the root of these changes. Indeed, the philosophical origins of self-determination can be traced from the French Revolution to the American, from decolonization to Kosovo, and yes, even to the Crimea and the Donbass. This case is historic. It narrates how Azerbaijan's current violations of international law must be considered in the historical context of a century of anti-Armenian racial and ethnic hate. From Adana to Van, from Maraga to Sumgait, Kirovabad to Shushi, and yes, now even from Berdzor to Jermuk. It translates moral repulsion into legal obligation, and therefore into tangible assets in the struggle for the security and dignity of the Armenian people. It's not a silver bullet, though. Make no mistake. The case alone is not going to save us. No single case, no single celebrity, no single billionaire, not even a single world power can do that. Only we can save us from the existential choke of the present moment. And that requires epic commitment. In epic, renewed commitment by each one of us, each one of you, our children, and even theirs, always to champion our dignity as an Armenian nation. The ICJ case is a historic brick in that wall of defense of human dignity. But it's not going to stop an army in real time. We know that. However, it is going to shape valuable, tangible outcomes. You see, law is a normative fabric that grows new thread precisely in these times of change. It happened after the World Wars, after the collapse of the Soviet Union, after war and devastation in the former Yugoslavia, and it is happening right now. If we do not step forward and weave our share of that fabric, it will be woven without us. International law and human rights, indeed the very ICJ case that we're talking about today, is at the core of this mission. When advocated with purpose towards tangible deliverable, as Levon was mentioning, it shapes legal principles, it molds global opinion, and thereby influences policy in capitals and outcomes even on the ground. We must contribute to the legal discourse if we are to shape the narratives impacting Armenia and Artsakh. We must contribute to the legal discourse if we are to ensure that the red line the foreign minister spoke of is never crossed. We must contribute to the legal discourse if we are to truly explain to the world why actual Armenian lives hang in existential balance. We cannot assume they understand that. The human rights abuses of our people, the deprivation of their rights and dignity as actual human beings, must be adjudicated, as ugly as it is, amidst all its degrading reality. Human rights must be seen in raw and teleological construct, an engine to secure dignified humanitarian outcomes amidst ongoing indignity and inhumanity against Armenians. Arman Tatoyan calls this a vital element in a state's human rights diplomacy. And it is precisely that, vital. An absolutely vital step that we cannot allow to be stunted this time. Not by genocide, not by war, not by ethnic cleansing, not by empire, not by fatalism, and certainly not by our own apathy. I thank you, Garo, and look forward to our discussion.
Carnegie and I met Dr. Giragosyan and Dr. Gevorkian 8 years ago in 2015 at a Paris conference, and we were immediately drawn to these brilliant Armenian scholars, Carnegie scholar in his own right, and I'm so glad that we were able to have you here, not in Paris, here in Southern California. I want to thank you all for your presentations. There are a ton of questions. I should warn you, I don't know how long this hall is available for us, but, and I spent time gathering 10 of my own into the night. Before we go into the ICJ case, I'd like to start by a question of mine, and then I'll bring in the audience's questions and see where we go, how far we can go. You know, we often hear about the Kosovo case, the ICJ case that's always cited for the principle of remedial secession, as being the exception and not the rule. By way of background for our audience, if I'm understanding correctly, the ICJ held in that case that Kosovo's unilateral declaration of independence was consistent with international law. Well, you know, for someone like me who's not an international law specialist, well, what's so different about that when you look at Artsakh's unilateral declaration of independence? And how is that consistent or not consistent with international law? So it begs the question, is the Kosovo case an exception to the rule? And if so, what is the rule? Dr. Giragosyan, what is the rule? You feel like you're back in law school?
Yeah, thank you. Yeah, it feels like back in law school. I'll try to be brief because the question is really deep and I don't want to bore the audience, but in 2 words, the Kosovo advisory opinion, what was the process about, just reminding the audience. The advisory opinion started based on the question presented to the court, a legal question presented to the court by the General Assembly, And the question was exactly framed as you put it. I mean, is the unilateral declaration of independence compatible with international law, or is in compliance with international law or not? In the framework of the legal proceedings at the International Court of Justice, in the advisory proceedings, according to the rules of the court, member states of the UN have the right to present their own legal briefs presenting their positions on the question. And many states have done so during that proceeding, and most of the states, although there were, of course, the question is not relating, we understand, is not only the Declaration of Independence per se, but it is more deeper. It relates to self-determination, it relates to external self-determination, it relates to secession, etc. And because of that, I think most of the states and all of the states in their legal briefs particularly were focused on that question and presented their views and their state positions, whether they regarded that external self-determination is allowed under international law or not allowed. And among those states were, for example, UK, I think Germany, Russia, I think they won't correct me if I'm missing anything, that they explicitly stated in their statements that the concept of external self-determination or remedial self-determination, as UK has used it in its legal brief, is allowed under international law, and the conditions for that, of course, are quite famous. And if we go back to the legal documents of the United Nations of 1970 Declaration on Principles of International Law, which interpret the principle of self-determination and provide the details when it is possible to secede or to exercise the right to external self-determination. And you have the case precedents of although national courts, for example, the famous case of the secession of Quebec, where the Supreme Court of Canada is elaborating on the notion of self-determination, especially in one of the basic or one of the key maybe elements regarding the external self-determination is exactly the matter or problem of existence of people or a group of people or nation. When it's at stake, then the right is triggered. That's very simple. But the court is, I think, in the Kosovo advisory proceedings, it also was revealed that this court is somewhat as a political body too. And the court tried to sterilize itself from this discourse of discussing this concept and notions, because those are highly politicized, and the courts only discussed this very specific issue, whether the declaration by itself is allowed or not allowed under international law. And the answer was, no, it's not prohibited under international law, it's allowed. There is no such provision that prohibits declaration of independence. And the other remark that maybe is valuable from the advisory opinion is the court's the interpretation regarding the application of the principle on territorial integrity and the relationship with the self-determination issue. I think the only issue that the court tackled from this very complex array of questions relating to self-determination is that. And the court differentiated in its legal position, saying that the territorial integrity as described under the Article 2.4 of the UN Charter creates obligations only for member states, not for peoples fighting for their self-determination. That's the differentiation. And by that virtue, there is no any controversy in that. And I think I'll stop here. I think it's already a lot.
Okay. Folks, I really I won't even have time to read all these questions, but keep them coming. I'm going to start by a question from the audience. I did not give you an opportunity to chime in. I think we're going to go to the next question, and I'll ask you to tackle that, Dr. Gevorkin. What are the likely tangible outcomes of the provisional orders against Azerbaijan? Have the extensive measures on the part of Azerbaijan to double down on its campaign of state-sponsored ethnic hatred affected the ICJ and ECHR judgments? Is there a separate case presented to international courts regarding Azerbaijan's well-documented war crimes? Why or why not?
I'll add only a couple of sentences to the previous question, though, and then I'll
Feel
jump
free.
in.
I'm here all day.
This,
I'm not going anywhere.
no, I mean, this event is held in a country which was created as an act of secession. So basically, what International Court of Justice said, secession is not prohibited. You can secede. Territorial integrity operates in a completely different environment. It operates in between states. If there is an entity within the state that wants to secede, there is nothing under public international law that prohibits that. Well, unfortunately, after you do secede, good luck keeping your statehood. And public international law does not provide an answer to that, because public international law has managed to regulate interstate violence. It has not managed to regulate violence in between states that are losing control over a piece of land and the seceding entity. So yeah, that's just a short remark with respect to the first question. On the second question, look, we need to understand from the formal perspective, provisional measures are not independent proceedings. Provisional measures, requests for provisional measures are part of the existing cases, right? So there is a proceeding before the International Court of Justice under the Convention on the Elimination of All Forms of Racial Discrimination. And as part of those proceedings, the International Court of Justice has granted the order on provisional measures. Whenever there is any new materials, any new violations, and Yerzy Kyriakides will be in a much better position to explain that, of course, as being the representative before the courts. But what basically happens in that case, you simply provide additional evidence to the court within the context of the existing state. You can, of course, also inform the court that the provisional measures have been violated and not respected, and that's something that Yerzy Kyriakides' office is constantly doing. And of course, you can request the court to apply additional provisional measures, which is also something that is being handled. But any kind of new violations, any kind of new evidentiary materials, that is are not turning or becoming an additional case on its own. They're becoming part of the existing proceedings. At least that's the format before the International Court of Justice. Before the European Court of Human Rights, any new violations pretty much trigger a new case. And at this moment, I have already lost the count, but we have like 4 applications, or already 5? 4? Yeah, so at least case at this moment in the context of the European Court of Human Rights proceedings, there are we're going to pretty much have 4, at least at this moment, we're going to have 4 cases, 4 Armenia versus Azerbaijan cases. Does that give an answer to the question, I believe?
It does, thank you.
It does, yeah, okay, thank you.
A 3-part question. Number 1, any real enforcement mechanisms for any ICJ decisions? Number 2, dangers of joining ICC? And number 3, any potential ICJ filings against Turkey for cultural destruction and continued genocidal policies? You want to tackle that, Karnik, and then move on?
I think that would actually be ideal for Yerzy.
I'm sorry?
That would be an ideal question for Yerzy.
Yerzy? Let me hand you the question.
Okay. All right. The question relating to the potential case against Turkey, right?
Yes.
If there would be it, I cannot tell it now. I wouldn't have to. So,
Okay.
just,
Dangers of joining
yeah,
ICC, though?
There is one case against Turkey which is pending in the European Court. I told about that. And the case is based on the European Convention on Human Rights, which is relating the direct participation of Turkey during the war through its military involvement and also political involvement, which is not, they're not hiding it, like Erdogan is re-emphasizing that every day, and Aliyev is re-emphasizing that every day, they're proud of that. But also using mercenaries, recruiting mercenaries and transferring mercenaries to the conflict zone, that's also another way that Turkey has been involved in a conflict and also created additional human rights violations. That's also the aspect of that case. That's relating to Turkey. I'll just try to cover up the ICC part, then colleagues will, I think, add. The ICC, dangers of joining the ICC now for Armenia. I don't think that we have dangers at the moment for joining the ICC. Just if we are speaking politically, I would think that that would be a good option to consider, considering the vulnerability of Armenia too now. The ICC statute has been signed by Armenia back in 1999. I'm just reminding you about that. And we have a Constitutional Court decision of 2004, which considers the statute of the ICC as unconstitutional by two respects. I won't go into details, but those, after that decision, we have amended the Constitution twice, at least. And maybe it's time to revisit that, because it is, and one of the, just mentioning for you also to, as a food for thought, one of the bases of unconstitutionality of the ICC statute was, among the other, with the other is the rights of the sentenced persons to receive amnesties and to be pardoned for the crimes committed, which fall under the jurisdiction of the court. But interestingly enough, the new criminal code of Armenia, which started to be enforced from July 1st this year, prohibits amnesties and pardons for the crimes of subject matter jurisdiction of the ICC.
Thank you.
So this is important.
I believe there was also a question about the enforceability of public international law,
Yes.
which is it's a good question, of course, and let's be honest, lack of enforceability or deficiency in the enforceability of public international law is one of the the biggest problems that we're dealing with. I believe I touched upon that issue to a certain extent during my presentation, but just to elaborate on that in a clear manner, judgments are not going to be enforced on their own. So if Armenia fails in incorporating the proceedings into its foreign policy, if it fails working with international organizations, with states on a bilateral level, with lobbying, fails to lobby its cause before in various capitals, those judgments are never going to be enforced. And at the end of the day, we're going to have just pieces of paper and complaining about the destiny of the nation and talking about paper scoops as opposed to iron scoops, as Armenians usually like to do. But what we really need to do is consistently work on the possibility of the enforcement of those judgments. Be that through lobbying certain sanctions with various states, be that active involvement with international organizations. At the end of the day, the UN Charter even provides for a possibility of bringing the issue of enforcement of ICJ judgments before the Security Council. And that has been done, in my memory, as I believe correctly, only twice. Why so? It's because basically the International Court of Justice has such a huge authority attached to it that, in general, lack of its enforcement is not something that is very often. That is not the same with the European Court of Human Rights. Unfortunately, European Court of Human Rights has a very, let's say, long list of judgments that states are having trouble abiding with, and that, of course, can be a problematic aspect, but I wouldn't be so pessimistic as long as the ICJ judgment is concerned. It will be enforced. The question is how effective and efficient it's going to be enforced, and how Armenia effectively is going to utilize it for its own benefits. So, thank you.
Thank you.
Garo, if I can just add on that. I think it's important to kind of step back a little bit and think about how states actually behave in the in their international relations, in the international climate. There is not a state, and there's not a single state, that says it's acting counter to international law when it takes an action. This is an important point. States like to claim or invent or what have you, that their actions are consistent with international law. There is no state out there that says, publicly states, that my actions are against international law. Now, what the value of an ICJ judgment is, from an enforceability standpoint, taken writ large, is that it creates a tangible asset, a thing, right? We have complaints, we've got evidence, but now we have an international tribunal that will render a decision, and by doing so, create on the state that it rules against an actual international legal obligation. Now don't forget, when states agreed to the jurisdiction of the ICJ, they agreed to be bound by their decisions. That's one of the formalities of doing so. It makes the argument that we are acting consistent with international law very difficult if there's an international court judgment stating that the following conduct is against, in this case, a particular treaty. And therefore, the state against which the decision is rendered now has an international legal obligation. So it serves two purposes. And Levon's point is really well taken. The value in diplomatic discourse, right? It becomes a thing that is on the negotiating table at some point, right? That there is this judgment. You cannot pretend that it's not there, Azerbaijan. We need to address this, right? So it becomes a valuable point for proactive diplomacy on the part of Armenia. But it also has a very devastating impact on Azerbaijan's public claims regarding its own conduct, and that's why I think when Yegishev refers to it as and Levon as well, as a deterrent, that's why I think it's valuable, because the state can no longer propagate its claims counter to an actual decision imposing a very specific legal obligation on that state.
Did you want to add something to that, Yegishev? Yeah, okay.
Very briefly, just two points adding to this enforcement issue relating to the ICJ decisions and the judgments. It has been and will be always a problematic process of enforcing international law. It is not always that the states, of course, I agree with Garnick that states are always, even the most dictatorship regimes, they are always trying to justify that they are acting in compliance with international obligations, and they put forward any justification for that. But still, the problem with the enforcement remains a little bit nuanced here, because international tools or international judgments are, especially also throughout the process, when you are in the process of getting a judgment, you are not finished, you are not there yet. As opposed to national courts, international courts have some detachment from the realities that they're adjudicating. That creates a lot of problems, because they don't necessarily see, or they don't necessarily understand the context. And understanding the context, you need to transfer the message from the ground to the international community. And the problem with that, I think it's what has been done or being done, for example, for the past decades by Azerbaijan, when Levon was mentioning in his speech about the efforts to create a legal narrative. I think it has been done exactly that. I mean, they have created that necessary narrative for the international community to understand that conflict from that angle. It takes time, and also enforcement takes time. So you need really to prepare for that. It's a very multi-layer work. It includes a very smart and very detailed architecture of diplomacy. It's not a one-day thing. You cannot just rely on Security Council, because Security Council is a very highly politicized body. And especially today, you have permanent members having their own issues with each other. And that's a huge problem, because for that, the countries need to do their own groundwork. A lot of work needs to be done. It's not only countries, but also people and scholars.
Gentlemen, the sovereignty of Armenia is being challenged militarily and even diplomatically these days, and the issue of sovereignty has become a richly discussed topic for Armenians everywhere. But sovereignty is an important legal concept under international law. And can you explain very briefly what it really is and why it matters so much? Harnik?
It's a good question. It's a fundamental question as to the creation of states, what it means to have sovereign capacity. And there's really, there's two really kind of basic theories on approaching this. One is, which is prevailing since 1948, is the idea of this sovereign equality of states, a positivist approach, which is enshrined in the Charter of the UN, right? Article 2.1 talks about sovereign equality of member states. So if you're a member state, now you are sovereignly equal to every other state, and therefore can take advantage of all the things, all the treasures, and all the riches that that sovereignty gives every member state. I'm not necessarily cynical about this, but I do believe it's extremely detached from the realpolitik, especially for states that are really in compromised geopolitical regions. There are some important, valuable tools, which Jelische mentioned, that sovereign, the entitlement to sovereignty, as reflected in the Charter, allows you to implement, such as, for example, access to the ICJ and other international instruments under the UN Charter and other things. There is another way to look at it. I like to look, there's a school of thought in international legal theory that discusses things under economic analysis, and I like to look at sovereignty as a pendulum. It's a basket of rights, and if you think about sovereignty in that respect, it is and constantly changing in the region, right? There are geopolitical movements, there are humanitarian crises, there are a number of external factors that then affect the power of the state to project its sovereignty, to project its rights upon other states that are also in continual flux. There are some arguments that the sovereignty of Azerbaijan post-conflict has increased, right? One capacity is military capacity. There's no question about that. That plays an important role. But there are other important capacities that play a role as well. So I think if you think of sovereignty as a collection of rights, some of which enshrined in the convention, in the UN Charter, that's one way to look at it. But I think a more intelligent way, in fact, a much more sophisticated way to look at it, is to think about it as a pendulum. And right now, there's no question that our pendulum has swung extremely to the left, if you will, in terms of the ability to project certain major tenets of sovereignty, which is military power, for example, economic power. But these actions taken in the courts are another expression of sovereign authority. This is a very valuable step by which a small republic, a small state, is able to project that sovereignty, is able to impact the international community in a way that starts to shape discourse, that starts to shape not even public opinion, but actually shape the nuances of the laws which it will then benefit from. So I think it's important for us to realize that sovereignty is not we can, in school we teach it under the positivist model, right? That, you're sovereign, so you get all these rights, and that's a very idealistic way to look at it. I think in reality it's a little bit more sophisticated than that, a little bit more complex, but it requires this ability to leverage not only military power, but all of these other powers and circumstances in a way to project the power of the state, if you will. And I think what Armand Tatoyan had spoken about earlier in terms of using international structures, this is one case. This is one example of using international structures. There are other international structures that can, should, and should likely be used. And I do want to say also, I think that people to have a kind of a perspective on this, that the work of Jelisce's office is really tremendous. It is, there's an amazing balancing in law. Those of you that are lawyers know this, that at some point, no matter how much you have, how much power you have, let's think about a domestic court in a case in the States, for example, there's something kind of humbling about a court experience. The rules, the procedural rules that you're entitled to are the same. It doesn't matter how much money the corporation has and how much money the plaintiff has in a particular case. What matters is that the procedures, you have equal access to the procedures. And I think that's where the value of these types of proceedings really allow Armenia to excel. And frankly, in the aftermath of the war, this is one area where Armenia has not only shined, largely due to the leadership of Yelishe's office, Yelishe himself in the office, but has made magnificent strides in advocating, literally advocating for sovereign, for the increase of sovereign, projection of sovereign power in a way that really many larger states are unable to do.
Thank you. You should see what's in front of me. There's probably about 30 questions. What I'm going to do is I'm going to go as quickly as I can. I'm going to ask you not to be me and talk forever, talk short. And then the rest of the questions, I'm going to suggest that the panelists provide written answers, and it will be posted on the ANCA Western Region social platforms. Yes, you are going to, because since you love to, inform and educate and activate, you're going to respond to all of these questions, and I'm going to oversee that you do it. That's how it's going to be. I'm sorry? And motivate. I forgot. I knew there was another word there somewhere. Gentlemen, are there any international mechanisms that we have yet to pursue to help Armenia and Artsakh? And if so, which ones? Thank you. Short, not like Garo, short.
I'll probably say which international instruments could be used. The status of those, I think, is not something that Mr. Kyriakosan will be in a position to disclose, but obviously there are certain conventions that come in mind right away when we talk about the 44-day war and the following and the 2 years that followed the war. Basically, it's going to be the Mercenaries Convention, primarily. It's going to be the Convention on the Prohibition of Torture and Inhuman Degrading Treatment. It's going to be the Convention on the Prohibition of Taking of Hostages. Those three conventions directly pop up when you think about the conflict. Interestingly, all those three conventions are international criminal law conventions, which also imply, just to clarify what that implies, it basically means any potential proceeding initiated under the auspices of any of those treaties would imply not only asking the International Court of Justice to recognize that Azerbaijan has violated certain obligations, but also that would imply asking the court to impose an obligation to prosecute the ones responsible, and also to extradite those responsible to states which are willing to prosecute them. Whether Armenia is going to file cases under any of those, time will show. So I'll probably cut there.
Thank you. Yeah. Question to Dr. Kyriakosan: does Azerbaijan have any cases against Armenia in international court?
Yes. Azerbaijan has one case against Armenia at the European Court of Human Rights, which they submitted after the war. Partly the case relates to portion of violations, alleged violations that were committed during the first war. And we have already provided, and some portion is relating to the events of July 2020 and the conduct of the war in 2024. And we have already provided our counter arguments and observations with regard to that application. And we will be waiting for the reply, and then based on that, another hearing we'll be having next year. That's ECHR. And we have a one mirroring application submitted by Azerbaijan in the ICJ. When we submitted our case based on the cert, they submitted a week later a mirroring application trying to create a balance, and also submitting a similar request to indicate provisional measures, which was mostly rejected. I think one thing that they only got was relating to Armenia's obligation to prevent any groups and individuals from inciting hatred, racial hatred, which is a normal obligation which the country still assumes under the convention. And then the rest of the measures that they requested relating to mining, relating to providing mine maps, which we're trying to stretch and to include within the scope of the SERP, which was evidently outside it. The court didn't consider, the court rejected. And there is this and that application is pending in the court. We're waiting for them to submit their memorial in January similarly, and we'll see. Those are the two.
Thank you. Real quickly, during the 3 to 5 years of trials to reach final judgments of violent wrongdoings, a whole country can be erased in weeks. Can the process be expedited to stop the cleansing and Turkish takeover? Being a student of the three of you, I think they're talking about remedial, or what do you call it, this interim orders, perhaps? Do you care to respond briefly? In other words, like while you're litigating and it's going to take 3 to 5 years, meanwhile your country can be wiped out in a couple weeks. Well, actually, you can. No, I wasn't. It was saying. There's another question that is kind of related. Is first of all, perhaps you can put it in context. Is cultural destruction under international law or conventions considered an act of war? But the question I posed prior to that is, what can you do rather than wait for the court to render a decision when you have invading armies, I suppose? Here are the questions for you to view it as well.
Well, destruction of cultural heritage is not an act of war in itself, but destruction of cultural heritage can qualify as a violation of the laws of war, which is a bit different thing, because there are certain conventions that protect cultural heritage from destruction and targeting during armed conflicts. But we're facing basically a different situation, because we're facing destruction of the heritage within territories under Azerbaijani control, rather than in the regions where active hostilities are or may take place. So no, they would not qualify as acts of war, but they would definitely qualify as acts of racism and ethnic hatred. And that's one of the reasons that we managed to incorporate those into the CERT proceedings before the International Court of Justice. Another proceeding, which is not a proceeding initiated by the state that is directed that is the aim of protecting the cultural heritage, is the case initiated by the Armenian Apostolic Church against the state of Azerbaijan before the European Court of Human Rights, on which Garnik and I have the distinct honor of being also the counsel for the applicant. As to what can be done to protect the values that the ultimate judgments are supposed to protect at the end, given that everything can be wiped out within a week. Well, we basically come back to the same talking point that pretty much I presented during my whole presentation: lobbying and narrative building. That's pretty much the only thing that you can do, that we can do to protect whatever there is yet left to protect, so that the final judgment has tangible effects at the end. If nothing is done, we'll of course get nothing at the end. So we need to cope with the realities that we're dealing with.
Let me just add one other thing,
Sure.
just to kind of translate some international law lexicon into perhaps something that might be more tangible for, definitely for Americans. The request for interim measures, or in the European Court of Human Rights, or provisional measures in the International Court of Justice, is the equivalent of moving fast, right? These are requests like a temporary restraining order would be in a state court. Law moves slowly. It moves even more slowly in international courts. So the, the Armenian legal team is taking the fastest actions that are possible under the ICJ statute, and even under the European Convention on Human Rights statutes. They are, there is a concerted effort to realize that time is of the essence, and those are issues that are impressed upon the court. And so I think that was probably a point of that question. Are there other things to be done faster? These are the fast mechanisms, if you will, under in this particular case, under the statute.
Thank you. Partly, I believe, this question has partly been answered, except for the latter portion of it. What can Armenia do to have ECHR and the ICJ enforce orders or judgments granted against Azerbaijan? For example, how can Armenia enforce a ruling of the return of our POWs?
I'll try to answer the. We have attempted to use both of the mentioned international courts to ensure the repatriation of the POWs. I'm sure you know about that, both the ECHR and the ICJ. And we knew that the possibility was not that of high that the court would grant that, but still we tried. Mm-hmm. The court didn't grant it because usually the courts are, for example, if we're speaking about the ECHR is not ordering repatriation because ECHR's the role is to order to secure the rights, especially the right to life and the rights from freedom from torture and human treatment, but they are not going that far as to order return. We have explicitly asked the court several times. We asked first, I think it was back a year ago, more than a year ago, and then a little bit more than next couple of times, and also we also included in our request of provisional measures presented to the ICJ in October, and we insisted on that during the hearings, but the court rejected that request, justifying its more legal term. I'll try to describe why the court rejected that, because the court considered that the right to repatriation or the right to be returned is regulated in the framework of the IHL, or International Humanitarian Law, and the ICJ is operating based on the third, the Convention on the Elimination of All Forms of Racial Discrimination, and in that scope there is no obligation to repatriate. And that was the justification of the court, which is in the order. So yes, we have attempted, but unfortunately those tools do not work to help the repatriation.
Thank you. Earlier, Dr. Karagusin, you spoke in your remarks about, in your opening remarks, you spoke about Convention on Elimination of Racial Discrimination, which I believe the ICJ case was brought based upon that convention. The question comes up, what other international conventions could be used to initiate proceedings against Azerbaijan and or Turkey? Did we cover that? About other conventions?
We covered other conventions as long as Azerbaijan is concerned. With respect to Turkey, Mr. Kirakosan elaborated that there is a pending case before the ECHR. Unfortunately, the thing with Turkey is that, pretty much like the United States, they like to make declarations, reservations with respect to the admission of the jurisdiction of the International Court of Justice when they ratify conventions. So they usually ratify conventions and then make declarations saying that they don't accept the mandatory jurisdiction of the International Court of Justice to settle disputes under the said convention. So they, to a certain extent, so allegedly they are bound by the convention, but there is no way to enforce the convention against them. So bringing Turkey to justice is a bit more problematic. But again, as I said, there's the ECHR proceedings. And as a matter of fact, those ECHR proceedings really hurt them bad. If you could see the reactions of the Ministry of Foreign Affairs of Turkey when those cases were filed, when the case was filed against Turkey, they pretty much perceived it as something, for them it was something unperceivable pretty much, because the notes that were sent from Turkey to the European Court of Human Rights when the provisional order for interim measure by the European Court of Human Rights was applied with respect to Turkey can pretty much describe as hysteria, because that is not something that is usually done by states, like official letters at the level of the Minister of Foreign Affairs filing complaints with the President of the Court saying that the interim measures are unacceptable, claiming that the case has to be stricken down. So Turkey pretty much feels itself to be the state that can never be brought to any international court by another state. But again, there is a case pending, and we'll see how it's going to work.
You know, oftentimes people have said that we should stop trying to get genocide recognition. The U.S. recognized it and move on. Here's the question. Given the history of the genocide, given the fact that neither Turkey nor Azerbaijan is a country that has recognized the genocide, and given the history of the Holocaust against the Jews, it's really impossible not to draw parallels between the two crimes against humanity. However, when it comes to the state's ability to exercise sovereign power to protect its people, we see a significant disparity. Israel has been able to protect not only Israelis, but Jews globally, some would say, whereas Armenia's ability to project sovereign power to protect Artsakh and even its very own borders now has been otherwise. So aside from military power and alliance issues, is there something more fundamental that we are missing? And why is there such a huge disparity in state sovereign outcomes? It's not a rhetoric one, and since my partner in All Things Not Crime, the good guy over there, is looking at me, go for it, Karnik.
Yeah, I'll try to answer that from a. I don't think that's so much a international legal principles in terms of a litigation-related issue. I think that the idea, this is really about state building. It's really about how the two states came to be. If we look at the Israeli example, I think it's fair to say, of anybody who's studied the origins of the state of Israel, I think it's really easy to think that the Holocaust happened. Because of the Holocaust, a state was created in Palestine. That's, I would say, the layman's approach. The truth of the matter is actually extremely different. Extremely different. There was an ideology which predated the creation of the State of Israel, which was at least 70 years old. In the 1880s, for example, European Jews had created a World Congress which identified the fact that there are significant perils that befall the Jewish condition in Europe. The ideology, you've heard of it, is Zionism. The idea of the Zionist thinkers at that point was that the only salvation for the Jewish people was a creation of their own state. this process, throughout European capitals and kind of in tune with the discourse of liberalism that was taking place in Europe at the turn of the century, really gathered a lot of inertia. This is 70 years before the creation of the State of Israel. The Holocaust was perhaps the thing that broke the camel's back, but the ideology of the state and the purpose of that state, what it's there for, that was an ideology that was created prior to the Holocaust as a solution for the state. Now, if we look at, the sovereign state that's created, that Israel was created for a particular ideological purpose, and that was for the security and protection of the Jewish people and for the prosperity of the Jewish nation. And I say this as a real kind of short, approach. And it's really funny when the British, you've heard of the Balfour Declaration, when the British wrote the Balfour Declaration, it's a letter. It's actually a letter, it's very peculiar, to an actual individual, Baron Rothschild, sent to his house in Lebanon, in London. I mean, if you think about that, the British recognition of a state is based on a declaration by the British Foreign Office sent in a letter to a London-based British citizen who happens to be Baron Rothschild. And that was years before the creation of the State of Israel, right? It was laid out the support. So there was an ideological basis to the creation of the Jewish state, which predated the Holocaust. For Armenia's sovereignty, if we think about where Armenian sovereignty came from, I mean, if you're looking at it from a purely theoretical standpoint, I'd argue that Armenian sovereignty is somewhat gratuitous. It came as a result of the collapse of the Soviet Union. That's exactly why Armenian sovereignty exists today. That's a very different basis, theoretically or ideologically, for the creation of the state. And what we see and Armenia is not the only state that was created like that. What we see are the bundle of sovereign rights that begin, that a state holds. For example, prior to the collapse of the Soviet Union, the sovereign rights were all held in Moscow. Happy birthday, surprise, here you have all of these sovereign rights now, Yerevan. And what happens then is through an equilibrium, there's a balancing of those rights. They're sold back to various states for protection, for other purposes, for economic development. And so you have that an equilibrium that's ultimately established. This is extreme. I mean, I think that the question draws the Holocaust and the genocide as kind of the state creation moments, but that is not the correct analogy. What the correct analogy is really a magnificent disparity as to why the state was created. The idea of having a national ideology as to the purpose of the state underlines the reasons for the state, the very reason that it exists. And every state needs to undergo that development. In the case of Israel, that development took 70 years prior to the creation in 1948. For Armenia, this is something, and again, this is my personal opinion, this is something in terms of state development, state creation, as to the purpose of the state. Why does this state exist? These are national ideological questions that need to be formulated so that we understand that, yes, Armenia needs to serve the following sovereign functions. Israel did the hard work, if you will, intellectually, on why they needed to create the state. There's no, if you read Theodor Herzl, Theodor Herzl had a pretty clear understanding of what that ideology was. That type of state-building analysis is something that we need to develop. We have it historically, but in the recent years, we need further development of that.
The question was, Mr. Kirakossian, why did we fail engaging international law? And here I thought, actually, we didn't, because they have been engaging. But here it is. He wanted to answer the question. That's the last question. Please make it short, Dr. Kirakossian. I'm told they're going to kick us out, and I'd like to invite, as soon as you are done, a member of the ANCA Western Region, Ms. Anahid Oshagan, for final remarks.
I think, thank you. I think the question relates to why we failed before.
we started.
Before?
Yes, I
Yes.
think before the moment
Okay.
we started engaging the international legal tools. I think that's the question. And the question is the real, very extended question, but I'll try to be very brief in answering. I think the roots of the relation towards international legal tools and international law in general for countries like Armenia, which has is a post-Soviet country, it has Soviet past, and are unique, and we have that complex of being a post-Soviet country, which impacts the thinking of the decision makers, because the decision makers have been educated in a certain manner, and the decision makers have certain stigma and certain values, and the influence also that continues to be, because in the region when the USSR collapsed, right, and newly independent standards were created, but culturally and educationally, things haven't changed much. We continued the same thread, and we haven't substantially made an effort to change or revolutionize. And that's one of the reasons we haven't been able to create the atmosphere, to create this momentum, to start thinking about that. Because Armenia has not been a sovereign country, it has been inside USSR. USSR was the sovereign actor, and of course we didn't have the necessity to think of that. And now as a young country, a state, now we have the opportunity of doing that, and I think that's one of the big reasons why we failed, basically, and there are also political and geopolitical reasons which I won't touch now. Thank you.
Thank you very much. The true warriors, each of you have stayed till the end, but please stay put. Ms. Oshagan, please.
On behalf of the entire ANCA Western Region Board, I'd like to thank each and every one of you, our phenomenal, extremely distinguished and stellar panelists, moderators, and guests who came to think that we almost canceled, that we even considered canceling this event. I must say, though this is one of the most difficult times, this is definitely one of the best grassroots conferences I have ever attended. Please join me in thanking everyone. And I believe our mission to educate, motivate, and activate was truly observed here today. Some members of the attendees mentioned, wow, I'm so glad I came. This has really been wonderful. Dr. Tatoyan, Foreign Minister Babayan, all our scholars, our legal wonderful minds that are working tirelessly to make sure that we do not lose our homeland, our amazing cultural heritage panel as well. We are so grateful to you and thank you, and please remember to join us tomorrow. We are all looking forward to our wonderful gala, which we haven't had in several years due to the pandemic, but now we are ready to honor all the work that is being done on our behalf, on our entire nation's behalf, on our diaspora's behalf. So please join us for the gala tomorrow, and we hope to see you there. And thank you again for participating here today.